Thanks very much, Shankar. It's a pleasure to be here. So thanks, everyone, for coming today, and thank you for inviting me. I very much appreciate it. I'm going to speak today about security breach notification, and if you like, we could talk about identity theft a little bit later. I have varying titles for this presentation, and this is one of my favorite ones. And of course, the title is a reference to a video game. And you guys might have known of "All Your Base Are Belong to Us," the famous kind of bungling of English that gamers made online. Well, I'm talking about how all your database may belong to a hacker. And so the basic overview for today is I'm going to talk about the California law that started the security breach notification rolling. I'm going to talk about the various things that are happening in Congress, but I'm going to kind of shorten that part of the presentation because it's a bit legalistic and boring. There are conceptual problems in security breach notification that we should talk about, and I'd love your feedback about how we could be better informed in shaping the policy on security breaches in that respect. And I also want to talk about our ongoing research on these issues. And my research team is my boss, Professor Deirdre Mulligan, over at the law school. Also, Drew Lewis, who is an undergraduate student here in political science, and my student Olive Huang, who is studying security breach notification, is actually interviewing people who have chief information security officer positions and determining how they have changed their investment and their allocation of resources as a result of these laws. So all of this started when California passed a law known as SB 1386. It actually does not have a name. It doesn't have a title, as many laws do. In a broad sense, it requires notice to consumers when there is a security breach. And the reason why this came about is when there's private sector polling showing that most companies do not tell anyone when they have a breach. And in fact, only 20% will even tell law enforcement, and that's different than telling the public. Most companies don't even reach out to law enforcement on these issues. The law took effect in July 2003. It was sponsored by Senators Peace and Simidian here in California. A little-known fact about this is that Deirdre Mulligan actually came up with the idea for the law, and she looked at environmental laws that required disclosure of toxic chemical releases. These are so-called environmental right-to-know laws, and you can go online and you can search on your neighborhood and see if there are any toxic chemicals in your neighborhood, and you can see whether or not there's ever been a release of those chemicals. So Deirdre took that idea and brought it to Senator Simidian, who shaped it into a law to deal with information security. The California law is peculiar because it applies to both state agencies. So it applies to the government in California and to private sector actors who are doing business in California. It doesn't apply on the county level. So the county of Berkeley could have a security breach and would not have to inform you of it. There's a loophole in the law based on the definition of possessing data. It doesn't apply to data processors, bizarrely enough. So the companies out there that will take your marketing data and look at it and add to it and tinker with it, they're actually not covered by the California law. And there have been a number of security breaches at one of the biggest information processors, and they never had to give notice of those breaches. So the definition of a breach in California is very broad. It is unauthorized acquisition of computerized data. So if I steal someone's laptop, I've obtained their computerized data. It can also apply to paper, because paper data can sometimes be computerized data. It's just a printout of computerized data. Then the question is, well, what is data? This is one of the bizarre things about the law, one of the many bizarre things about the law, but it's hard to codify this type of security law, so you have to draw the line somewhere. It only applies when you have the first name in combination with either the Social Security number, driver's license number, or a credit card number. So it doesn't apply to all security breaches, just the ones that touch on these sensitive forms of information. If one does not comply with this law, one can sue under a very broad consumer protection statute. in California known as 17-200. The default damage is probably $3,000 a violation. There are tons of breaches as a result of this law. We know about tons of them. If you go to the Privacy Rights Clearinghouse website, it's privacyrights.org, they're trying to catalog all the breaches. If you print out that list, it's just a text list, it's 30 pages long. And there are so many breaches now that they cannot keep up with updating it. It is literally taking too much time to simply document all the breaches. There have been hundreds. The biggest database I know of records 500, but there's probably more. So California had this idea: we're going to ask people to give notice of security breaches, and it took off. And other states, as they often do, copycatted the law. This frequently happens with California. California will come up with some idea for consumer protection law, and other states, especially in the West, will simply copy it word for word and stick it into their statute, into their codes. So this is a little out of date. It's probably 35 states that now have security breach notification. Many of them don't cover government agencies. They only apply to the private sector in these other states. One of the compliance difficulties is that some of these other state laws cover other forms of personal information. So, for instance, in one state, if your signature is stolen, it is a security breach. And just imagine dealing with that. If you're running a company and you're collecting signatures for some reason. Some create safe harbors to reduce requirements for notice. So, for instance, likelihood of harm is often a standard one sees in these laws. So if you can do an audit of your security breach and determine that there was no likelihood of harm to the consumers, in a lot of states you don't have to give notice. But the long and short of it is you have these 35 states. Some of them have different standards. So doing minimum compliance is basically impossible. You can't say, I'm going to follow the Iowa law to the T and the Michigan law to the T and the California law to the T. You'll end up violating someone's rights. So what's happened is that there are best standards that are evolving, and I think this was first articulated by ChoicePoint. ChoicePoint had a breach, and they originally only notified people who lived in California. And people outside of California said, well, hey, wait a minute, what about me? Why don't I get notice? And there was all sorts of regulatory heat about that. Lawsuits were filed, and ChoicePoint said, wait a minute, we're going to give notice to everyone. And that trend, that rise to the top, is one of the things we're seeing in this field. So this next section of the presentation deals with federal legislation. I'm going to go very quickly through this because it's not as exciting. Yes, Shankar?
I'm supposed to hold questions to the end. So you've said all the drawbacks of 1368. Can you say some of the positives of...
Oh, sure.
Can I just sort of get you going? So what was good about 1368 is because companies have to report it. Because companies have to... I will steal your thunder, so I'll stop in a second. But because companies had to report it, like the University of California at Berkeley, by the way, when we got our Social Security numbers of... when the laptop was stolen, a lot of us got notified by the university. What it did is it creates a system of incentives for companies to not, who really dislike writing to their customers to say, oh, by the way, your information was stolen. So that's sort of what went into Deirdre's formulation.
That is exactly right. And let me amplify that. This law is really, it's revolutionary. We have evidence that companies have reduced collection of personal information because of the law. I have one security breach notice from a fraternity that had a security breach, like a college fraternity, and they lost all the applicants to their fraternity, their applicant database, and it had the Social Security number of all these students. And in the breach notice letter, they write to the students who applied. They say, you know, we've always collected these Social Security numbers, and I don't know why, and we're not going to do it anymore. There's no reason for us to do it, and we're not going to do it anymore. And those are some of the effects that this law has. It's created incredible incentives for research and development in encryption. So the law has had many great effects. I think there are still a lot of questions around these laws. Whether they reduce identity theft is a good question that should still be asked. How many of these breaches actually have to do with malicious use of data and how many of them are just the product of accidents or people hacking for vanity purposes. I want to find a way to talk about these laws in a most optimal way. And I also want to find a way that the law will encourage more investment in technology outside encryption. Because the current safe harbor, the current way you get out of giving notice is you start encrypting your systems. Well, there might be other technologies we should be talking about too. And we might also maybe we should also talk about whether or not there should be such a strong encryption safe harbor. There are situations where encryption is breached, right? So all of those issues are floating around in my head as we think about federal legislation. Because as a result of all these states having these laws and different standards, it is creating an incredible amount of momentum for federal legislation. There are a lot of bills on the floor. The common element, the one thing that they all share, is preemption of state law. So what the lobbyists on the federal level want to do is wipe out all these state laws. They want a single national standard. That's understandable, but there are drawbacks to it. There are serious drawbacks to this approach. So the issues being discussed on the federal level, what is a breach? And these are kind of the biggest issues that you'll see in these laws. What predicate information is going to trigger a breach? How aware do you need to be of the breach before there is a breach, if that makes sense? There are breaches that occur that you don't know about, right? So how aware do you have to be of a breach? Risk of harm is an issue, and of course safe harbors are an issue too. On the federal level, all the bills are only talking about electronic information. And this is huge, because here on the state level, we keep on trying to expand 1386 so it will apply to paper. And it makes sense to extend it to paper, frankly. You can go outside of a lot of businesses and root through the trash and find stacks of paper with personal information on them. This is a problem that's been addressed in some areas. So, for instance, it is illegal to take a credit report and put it in the trash can. It's against the law. You have to shred it. But it doesn't, my consumer database that I keep on paper that contains Social Security numbers or whatever, I can throw that in the trash. I could get sued, but there's no law saying specifically not to do that. So on the federal level, we're only talking about electronic records, and that is a big deal. Some of the bills make distinctions among how many records were released. So if it's a small breach, you don't give notice. I don't quite understand that. But if it's a big breach, you do. And of course, there are small breaches that are very severe, and you should give notice of small breaches. But then there are big breaches that don't really matter for various reasons. So that's another bizarre thing that's happening. A lot of the laws will exempt information that's publicly available. And while that sounds reasonable, a lot of your personal information is publicly available. If you have ever bought a home, chances are your Social Security number was printed on the deed and filed on the public record. So if there's a security breach and your Social Security number is released, shouldn't you get notice anyway? Why should the fact that your deed somewhere in the world has your SSN on it, why should that exempt the company from giving notice? There's all sorts of different levels of knowledge that are being considered in these bills. One is discovery. Well, what does discovery mean? The second standard is actually very difficult to deal with. Reasonably likely to have occurred. A breach is reasonably likely to have occurred and be unavoidable. And information reasonably identifying the nature and scope of the breach must be available. Now that second part, right? You often don't know how big the breach is. You often don't know how it happened. So why should you not give notice if you can't determine its scope? And then, of course, unauthorized access, which is the California standard. There's a lot of risk of harm and burden of proof issues in these laws. So a lot of the federal law allows the business to determine whether or not there's been harm. And we think that's a big problem. Because, of course, there's all sorts of economic incentives to say that there is no risk of harm. So this last standard I actually think is the best. It was actually written by the attorneys general, the state attorneys general, and they require basically the business to prove a negative, which is hard to, of course, it's impossible to do, but in this context it actually works, because if they can prove a sufficient set of facts that nothing happened with the data, they don't have to give notice. Under these other ones, they can plead ignorance and say that no notice needs to be given. Encryption, of course, plays a role in a lot of these bills too, and it basically creates a rebuttable presumption that there was no harm. There's no risk of harm. And of course, if, for instance, the encryption keys were stolen or encryption passwords were stolen, that can reverse those standards. So, there are some problems. There's still some problems with these standards that I think are worth thinking about. First of all, the laws are generally under-inclusive. They generally are aimed at protecting against identity theft, but security breaches occur for other reasons. So, for instance, I worked a lot in the Hewlett-Packard, before Hewlett-Packard, but in other pretexting cases over the years. Sometimes you engage in a security breach not to steal someone's identity, but to find out where they are, or to surveil them, as what happened in a Hewlett-Packard case. So if you have, for instance, in domestic violence cases, there are often security breaches associated with finding the former spouse or the former girlfriend. I worked on one of these cases called the Amy Boyer case, where a young man was used pretexting and was able to get personal information, and he stalked and killed a woman. So there's other types of harms out there in security breaches I think we should be thinking about aside from identity theft. But the rules are probably a little bit over-inclusive too. And for instance, here in California, you can have a security breach, and even if you can prove that there's really no risk of harm, you have to give notice. And there's probably situations where you shouldn't have to give notice if you have systems that protect consumers in effective ways. More problems on the federal legislation. One of the biggest issues in these laws concerns how will they be enforced. The banks want their so-called functional regulators, and this is going to sound very cynical, but there's about 7 different agencies in Washington that regulate banks, and almost everyone who works at those agencies comes from the banking industry. So they're very the functional regulators are a group of agencies that tend to be very friendly towards the banks, and so the banks want those regulators to be overseeing these issues. The Commerce Committee and generally people in Congress want the Federal Trade Commission to do enforcement because they are more independent, and it's actually an independent agency. So that's an important role. State attorneys general will have some role in enforcing these laws, but the main thing that the federal legislation does is it strips you of the ability to enforce your rights. So basically all the bills say there should be no private right of action. You shouldn't be able to go to court and sue if one of these laws are violated. So the general guidance for companies based on the breaches we've seen is, number one, you have to think about laptop control. There are large companies in the U.S., especially consulting firms, right? They have hundreds of employees, thousands of employees traveling all around the nation. They're constantly having their laptops stolen. So a friend of mine from one consulting firm says that they lose at least one laptop a week. And they have integrated a full enterprise encryption system as a result, so they don't have to give notice. Every one of their laptops is encrypted. Everything's encrypted. Reducing the amount of so-called trigger information you have as a business is also very important in preventing breaches. And then, of course, tightening third-party information sharing is really big. Because if you are any company, okay, and you send out your database to another company to do analysis, to do any type of service on your data, and that company has a breach, you got to give notice. And there are a lot of examples of companies that have lost a lot of goodwill and have really taken it on the nose because their partners have released information. And so let me get on to some of the good aspects. I mean, one of the greatest aspects of this law is how it encouraged encryption. Now, this quote I actually think is somewhat scandalous, and it's long, so I'll let you read it. But Lisa Soto is a big-time information security lawyer in New York, works for this big firm, is very well respected. She was telling her clients not to encrypt a year ago. This law changed that. She's now saying that the economics are such now that you want to start investing in encrypting. this is a big change because this type of lawyer is representing all sorts of brand name businesses, all sorts of big businesses out there. So this is one of the contributions of this law that Shankar mentioned earlier. One of the big issues that we've been trying to figure out are the economics of breaches and whether or not the breaches themselves harm companies when they occur. And what's really interesting is that in the biggest study that to look at this issue looks at only public companies, and it looks at their stock price before and after the breach. They find that there's only there is a negative effect on companies. Their stock price does go down, but the reduction is ephemeral. It goes away, and their stock price comes back up. So it's not clear that privacy breaches are scaring off investors. I'll just give an example. TJX, the TJ Maxx company that just had this huge breach, their stock price is actually up. The same is true with ChoicePoint. Despite having a rather disastrous security breach, both their revenue and their stock price are up, and they even gave up some business. They even said that they would no longer deal with private investigators anymore because they were the source of the problem with their data. So they gave up $20 million in revenue, and they still had revenue increases, and they still had stock price increases. What's interesting about this study is that while there was a negative impact on regular companies that had a security breach, if the company was a data processor, like ChoicePoint, like Axiom, like Experian, it's very unlikely that their stock price would go down. So what's odd about this is that the companies with the most data, the companies whose business is data, are very unlikely to have any stock price decrease as a result of a breach. The other type of incentives from these laws are audits, the cost of sending notices. The banks are saying that consulting firms for the banks are saying that sending out a notice costs $75 per customer. And the reason why is that issuing a new card costs about $20. Running the cards, a call center is very expensive. So if a consumer gets the letter and calls in, that can cost a couple dozen bucks. They're also paying for credit monitoring. Some companies are paying for credit monitoring and other remedial services. Looking at our numbers, this is actually not that many. It seems to be mainly big businesses are paying for credit monitoring. Smaller ones don't seem to be. And of course, lawsuits have come from these breaches. ChoicePoint was sued probably a dozen times from their security breach. And I imagine TJX and some of the other guys will be sued as well. One of the interesting parts about our research is consumer attitudes. Yes.
So when
I can bring it to you. Here you go. You got to turn on.
When the company has to notify the customer, so do they have to notify with the telephone or the regular mail or the electronics? So what's the right way of notification?
It depends. Well, it depends on each state law. The general rule is that you're supposed to send them a letter, a postal mail letter, and that raises all sorts of issues. For instance, what if you do not have their postal mail address? And so the law can create an incentive to collect that information, right? Or to go buy it. So the law, in a weird way, can increase incentives to collect personal information. However, if your breach is big enough, you don't have to send out a letter. What you can do is you can put a note on your website and then call the media. And that approach is kind of a safety valve approach. I'm not sure how much longer it's going to work because it's clear that the media isn't really covering this stuff as much as they used to. So the general rule is you send out a letter. You can do it by email, too. So what happens when you get one of those emails, one of those letters? Consumers think they're junk mail. They throw them away. And there's been a lot of thinking in trying to figure out how to avoid this problem. And so, for instance, here in California, the guidance says that when you send out a security breach notice, you're not supposed to have anything else in that envelope. No marketing, no anything else. So that consumers think that it's a serious letter and that they have to read it. Of course, we're seeing some really interesting letters. I have this great letter from H&R Block. And it starts out, the first paragraph says, you recently received a copy of H&R Block's TurboTax in the mail. We hope you enjoy this, this impressive product. It'll help you do your taxes, blah, blah, blah. The second paragraph says, unfortunately, in mailing you this CD, we put your Social Security number on the mailing label. And it was, a mess up, and we're very sorry. But you can imagine if you got this letter, you probably threw it away on that first sentence, right? You're like, I don't need this. A number of consumers, when you ask consumers what happens when you get a security breach notice, 19% of them say that they leave the company. I don't think it's true. I think they say they do, but they don't. And there's a lot of data to support that they don't. They don't leave the company. And then there's all sorts of weird public polling. So a clear majority of Americans think that they don't need more regulations. They don't trust regulators to solve this problem. But then when you look at this statistic, they always want notice. So they want more regulation, but they're saying that it's not going to help in a weird way. But then again, when you ask them this question and then follow up by saying, do you know what encryption is? A fifth of them say, I don't know. I don't know what encryption is, but I want to know if there's a breach. A lot of as far as numbers go, educational institutions have the most security breaches. There's a number of reasons for this. One of the biggest reasons is that the California law requires state agencies to give notices. In other states, it's not the case. Educational institutions are very difficult to manage. You can't impose rules on students and faculty that you can impose in the private sector, as we all know. So they're extraordinarily hard to secure. But then when you look at the breaches, when businesses have breaches, they tend to be much bigger. So UCLA might have a breach releasing records, but then a credit card processor has a breach, and they release 40 million records. So it's really out of proportion. The business breaches are much bigger, but they're less prevalent. And in most cases, it's loss or theft of portable media, meaning laptops. It really is the laptop that is the vector for these problems. Let me talk a little bit about my research here, and then we can go on for questions. What we've done is we've gone to the California Office of Privacy Protection, the New York Consumer Affairs Office, and some other places, and we've gotten our hands on as many breach notification letters as possible. And what we're doing is we're taking those letters and we're looking at them very carefully, and we're coding them for 34 variables. We're trying to figure out things like whether or not there was a relationship between the victim of the breach, the data subject, and the business. We want to see what types of businesses are having breaches. We want to see whether it's a third party that had the breach instead of the first party, that is an outsourcing company, for instance. We want to see what information was stolen, how it was stolen. One of the more interesting things we're seeing in almost all the letters is the businesses tend to reassure the consumer that there's no risk of harm, even when they have no evidence. I mean, in a lot of the letters, it's pretty clear that they don't know what happened, but they still say, probably nothing will happen to you, dear friend. And of course, we're also measuring whether remedial measures are made, and that's usually free credit monitoring. And it looks like it's a best practice mainly among big businesses. It looks like a lot of people are having breaches, and they're not offering any remedial efforts. We have a lot of really interesting breach letters that we'll publish in our study when it comes out, including ones that basically say nothing. That they say, dear customer, under California law, we are required to disclose whether we've had a security breach. We've had a security breach. And that's it. We have letters where there's no instructions on what to do. We have letters where the letter itself is undated. So you get this letter in the mail, and you don't know when your information was stolen. And with a lot of these companies, like Wells Fargo has had about 5 breaches. If the letter isn't dated, you don't even know which breach pertained to you. So there are serious problems with the letters, and I think our research is going to be able to provide some guidance for the industry on where to go from here. And of course, looking down the road, what we're trying to do is, and this is really Olive's work, we're trying to figure out how the security breach laws contributed to collecting less personal information, which we call minimization and privacy law. How encryption is being deployed, whether or not new database architectures are being made. So for instance, in the California law, a breach occurs when you have name combined with a social security number or other information. So what if you create a bifurcated database? You keep all your names over here, and you keep all your social security numbers over here, and you never combine them except, for instance, when the customer calls in to the service center. That might be one way to avoid breaches. So all of these issues we're looking at, and if you have any suggestions for what we should be studying, I would really appreciate it. And it's great to be here today, and I thank all of you for coming.
As a consumer, what damages are likely to occur for me? How can I connect whatever damages occur with a particular breach, and what can I do to ameliorate the possible effects?
That is a very good question. A group called Javelin Research claims that 6% of security breaches result in identity theft. There might be other types of harm. For instance, domestic violence is the example I gave earlier. There might be other types of fraud involved in stealing databases. So one of the things we're trying to determine is the relationship of these breaches to identity theft. Which breaches are important? Which breaches require people to really pay attention? And which ones don't. The most important thing that I think anyone can do is to regularly request their credit report and to review it for errors or other bizarre entries. And so anything that is on that report that doesn't look like you, a collection, a note from a collections agency saying that you never paid your car bills and you don't own this car, so you don't know what they're talking about. And you can do that by going to annualcreditreport.com, and you can get three free reports a year. So what you could do is every 4 months you could go up and you could go online and request one of the 3 reports and review it for accuracy. The truth is that there's little that people can do to avoid security breaches. Our information is in all sorts of different databases, and all sorts of different people all over the world can access it. So it is very hard to reduce one's risk of harm. Yes, sir.
Can I say something more about the answer?
Sure.
Sorry.
Oh, no problem.
So the answer to your question, let me tell you something about UCLA. So, the University of California story, 800,000 names were leaked out of, does everybody know about UCLA? Okay, so in about November, over Thanksgiving weekend 2006, a systems administrator noticed stuff leaking out slowly at the rate of sort of 8 identities per hour out of some set of databases that they had at UCLA, and he thought it was odd that this should be happening over the Thanksgiving break, and so he went back and started looking at the logs, and then he noticed that this had been slowly sort of leaking for the last 10 months before that. And this was so then they sort of figured out that there had been a piece of spyware that had been installed on an unpatched machine, etc., different kind of vector than the theft vector that Chris talked about. And so then there's 800,000 identities that were stolen. So those were the identities that were stolen. So the questions arose as to why would somebody do it. And the forensics, the University of California forensics, which is the only piece I want to tell you because it has some bearing on your story, estimate that the cost, if you can find a buyer for one of your identities, about $50 for a generic identity. If you have credit card numbers and if you have somebody's financial health, and if you know that somebody's actually wealthy, then it sells for more than $50. So in any case, and in fact there are places that will actually determine that this identity is worth $50 or $100 or something like that. So what this means, though, is that even at 800,000 names, and as Chris says, it's the businesses that have hundreds of millions of names rather than tens of millions of names rather than 800,000 names, which is still less than a million. I think that the issue is it's $40 million. So if you just sort of take 800,000 multiplied by 50, it's $40 million. So at $40 million, it's actually worth it for companies, for nefarious entities, not companies, nefarious entities, to actually try to customize their attacks to specific institutions. In this particular case, this is a bunch of people who had gone after the University of California, and they'd gone after a particular set of vectors that they had found unpatched and so on. So the part of what's going on, and the reason that educational institutions, in my opinion, are showing up is not only because we have to report them, but I think there's value in there that are less guarded, I think, than the other entities. And so that's sort of what the money story is, at least as far as the academic records are concerned.
One of the bad developments in this field is a lot of hacking. I mean, I think hacking has changed over time, and so there's a lot of computer attacks that were just done for vanity purposes, right? But now there are more and more people engaging in computer attacks to make money, and that's brought rationality to computer attacks. And exactly as Shankar says, there is incredible money in targeting certain people and for attack. Yes?
From your presentation, there seems to be, in the last slide, there seems to be this tension between what hardening of systems can do and what graceful failure can do to help prevent graceful failure, for lack of a better word, is that if a system is leaked, the damage is minimized or it's not even effective. So can you comment a little bit about what the schools of thought are and where people are moving? It seems like hardening is the way is what people are gravitating toward because there seems to be a sort of a technological approach that might be useful, but maybe you can comment about that.
Yeah, I do think hardening up front is the definite trend, and the reason why it's very difficult to write a law that gives a business discretion over to certify to itself that its systems are gracefully fail. There are incredible incentives not to give notice. It's embarrassing. Regulators start calling you. Trial lawyers start suing you. So I think the investment has been on hardening up front, but we should be talking about graceful failing. And one of the things we're doing here is we're going to try to amend the California law to allow other types of safe harbors in. So currently the safe harbor is for encryption. Your data are encrypted. You don't have to give notice. Well, we want to think about that a little harder. But we also want to think about other types of techniques that can be used, especially data destroying techniques. So maybe you don't want to encrypt your data because it is too complex or too expensive, but instead you're going to have some type of tether for your laptop that destroys it if it is stolen. We're still trying to figure out if this is possible. There are people in the private sector who say it is, and there are people here who say it isn't. So we're trying to figure that out. And meanwhile, while Shankar was speaking, I brought up another slide here from a different presentation. This is another advance that we're looking for in the federal law. This is a result of the New York law. And so what this is a form. And if you have a breach that affects New York residents, you have to take this form and file it with consumer protection authorities in that state. And what's so cool about the form is it solves all the problem with notice. There's no puffing. There's no kind of exaggeration on this form. You have to say the name of the company. You have to identify who is responsible for dealing with inquiries. A lot of these letters we get, a lot of these notification letters have no information about the business. So you don't know who to call. It has a very short explanation of what happened. And it identifies when the breach occurred, which is really critical, and how many people were affected. So you can see with this breach, date of discovery of breach was December 12th, 2005, but they did not give notice until January 14th. Too late for this, people, right? Probably? Right? They're probably, if there's going to be identity theft, it's probably going to happen. So one of the things we're thinking about is that if they have to file this form and they have to disclose these dates, they'll get closer together. They'll be embarrassed to do this type of thing. Any other questions? Yes, sir.
Yeah. We've had several legislative fights over sharing of information between companies, companies selling their information to some connected company, and we've worked and not done a very good job of getting that to happen. But it sounds like some of the information is now a liability, and therefore, maybe people will not be so eager to get that information from some other company if it increases their liability. That was the first question. The second one concerned the AT&T monitoring supposedly calls and giving the information to the government, and the person responsible for blowing the whistle on that, I guess, breached security of some kind, but I don't know. And so I'm wondering how that, he breaches security, but in the public interest, and how that might complicate the issue. Thanks.
To the first question, information as a liability, that is exactly Professor Mulligan's theory. And so this is actually from one of her presentations that she gave at DMAX at Rutgers. And the analogy she's making here is to the environment, and the idea that personal information is something like toxic waste. And so you gotta make it. You make it sometimes. You have to generate it for certain purposes. But once you've generated it, it creates huge liabilities. Some people want to just put it in a drum and bury it, but then it might leak. So you got to figure out ways to create what she calls a flexible duty of care and flexible incentives to reduce creation of this information toxic waste, but also to figure out how, once it is collected, how to assign liabilities to the collectors so that they do fair things with it. They don't just bury it and never think about it again. They do something responsible with it. So the environmental analogy, I think, is apt, and I actually think that information privacy is the environmentalism of our generation. I think we're going to, as we've moved to a digital world, increasingly we will be we'll care about information privacy, just as we cared about the environment as we switched to an industrialized world. Mark Klein, who was the leaker in the AT&T case, did take confidential documents and gave them to me and to the press and to Electronic Frontier Foundation. He did not break the California security breach notification law because his disclosure did not include any of the trigger information. However, he did release information that AT&T considered confidential. And the court in the AT&T case has basically said that if AT&T wants to, they could sue Mark Klein. Doing so is very risky for a number of reasons. Politically, it's risky. But second of all, California has a SLAPP law, which basically says that if you bring a lawsuit against someone for exercising their First Amendment rights, they can be liable for damages. And so suing Mark Klein is perilous. Any other questions? Yes, sir.
Mentioned that I think it was about a 20% number of companies with breaches, their stock price had gone down. Did that take into account just sort of the random ups and downs of the stock market? Is that actually statistically significant? My second question is, with laptop theft, is there any sort of numbers on how many of those are stolen and sort of search for data, and how many of those are just stolen because laptops are expensive items that can be resold? Thanks.
Those are two very good questions. And so let me go to this slide because it gives you the there it is. Acquisti, who I believe is part of Trust. Is that right? These guys, yes, they did compensate for fluctuations in the market. They were able to look at it. There's literally been hundreds of breaches. So they've been able to look at a very large number of public companies. Let me make sure that I present this clearly. They generally found that a security breach had a negative effect on stock price. And so most companies they're only looking at public companies have some type of negative effect on their stock price, and it's ephemeral. It goes away. Their stock price comes back up. But it's only 28% when it involves a data company. And that is the really interesting aspect of these laws is how do we change the incentives so those companies with the most information have the right incentives to do what the right thing. As to your second question, we don't know the answer to how frequently a stolen laptop results in identity theft, or if it's just stealing it for the hardware. It's a very difficult thing to measure. The only survey that I've seen on this was done by Javelin Research. I believe it is publicly available, and they say that 6% of breaches broadly result in identity theft. I actually am not sure what their methods were for determining that. It's a very difficult thing to measure.
I have 2 questions from Santa Cruz. The first is, what do you think about the Seagate hard drive installed into new laptops that are encrypted themselves?
I think the Seagate has introduced a new product that has full disk encryption. It's hardware based, so you don't get a performance hit in your laptop. I don't know how much it costs, so I don't know about those issues. But we think that the Seagate drive is an example of this law creating the right incentives for security. I go to trade shows now, and I walk around and I pick up product literature that says, "Buy our product; it prevents security breaches." And that literature didn't exist 5 years ago. People didn't care about security breaches like they do today. And you can find that the marketing is now ubiquitous. And so I think it's a great advance. I don't know anything about the technology behind the drive, whether it works or not. That's a good question. But it's a great advance, at least in theory.
And also, the other question from Santa Cruz is, what happens if encrypted data is leaked, but there are flaws in the encryption?
You have to give notice. Under interpretation of the law. The statute doesn't say that. The statute doesn't specifically say that. But if let's say, your database was stolen and it was encrypted, and the thief also got the key. Let's say that the thief was an insider, which is very common. You have to give notice because those data are no longer encrypted. If they've got the keys, you've got to assume that the data are not encrypted. Similarly, if the encryption methods are flawed, most lawyers in California will tell you that you have to give notice. Now, you could try not to. I mean, you could, and there are some companies that say, you could argue it either way, and I'm going to decide not to give notice. But the damages in California are $3,000 per incident. So if it ever becomes public, you could be looking at end of corporation liability.
I just had a quick question. Is there a way you could, I'm trying to think of a broad solution. If there was some sort of if each individual was in control of their own data, and in order for these companies to access the data, you'd have to give them permission. So they'd have to hit a website or something that you were in control of. You were able to have check boxes on everything that, like if it was a Time magazine, you don't want to have them have your information anymore, you could uncheck it and they could no longer have access to it. Is there any way we, in the future, may be able to have this kind of control over our own data?
This is a very good question, and it has to do with shifting basically ownership of data in order to secure it. I know of at least 2 companies that are trying to do exactly what you describe, and the idea is to create a cooperative. The company would be a co-op, and you would opt into it, and you would put all of your personal information into the database. And then companies that wanted to market to you would have to pay the co-op for the right to get certain information about you. Let's say your income level, the fact that you are shopping for a BMW, etc. You could go into the co-op and you could buy this information and you could market very precisely because people trust the co-op And in fact, they make money from the co-op. Their data are sold to these companies, and then or accessed by these companies, and then they get some type of revenue from it. It is very idealistic, and there are theoretical problems with propertizing personal information, and the best work on this is actually done here at Berkeley by Professor Samuelson, who wrote a paper called Privacy as Intellectual Property, I believe, is the name of the title. And it discusses how if you switch these rules, you are very likely to be coerced into constantly giving out your personal information. So the response are these co-ops, right? This idea that you could create this cooperative database. There's a guy at RICO working on this, and there's a company working on this, but I can't remember the name of it right now. Yes, sir.
I had a question regarding the international nature of business nowadays. Many companies nowadays are offshoring their IT divisions and also their call centers. And I've read in articles where some companies who offer to do your taxes are actually offshoring that business as well. So how does are there international best practices being developed in this area as well?
This is another excellent question, and there's a huge amount of tension around this. So there are what's bizarrely happening in a lot of countries. It's not just India, it's Jamaica. It's a lot of countries where there's a very large percentage of English speakers. There is a tension on one hand to create data privacy laws and have an enforcement scheme. And then there's the business community that doesn't want any data privacy laws. And what's a little bit bizarre about that is that for the business community to really come in and to operate, they're going to need to have some infrastructure of data privacy. So there's that tension there. If you're a California company and you're outsourcing customer data to another country, and the data are stolen, you're going to have to give notice. There's no doubt, because you're doing business in California. It's Californians' personal information. It does not matter that your data center is in Jamaica. You'd have to give notice. There's probably cases where that's buried. But one of the interesting things about outsourcing is that many of the banks have stopped their outsourcing. The reason why is they experienced so much fraud, they couldn't make it profitable. Yeah. Pretty amazing development.
Questions for Chris? Okay, well then, let's thank him.
Thanks very much. Oh, thanks.